Should you sue the debt collector's lawyer when you're sued for debt? Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. As many people know, original creditors are treated differently than debt collectors. The Fair Debt Collection Practices Act, FDCPA, applies by and large just to debt collectors and gives original creditors a relatively free ride. So where do the lawyers fit in? Can you sue them? And should you sue them if you can? Lawyers are not protected under the FDCPA. They can be debt collectors, and as a practical matter, the one suing you almost certainly is a debt collector. However, if the lawyer is representing an original creditor and acting in its name, he will be treated as an original creditor for things done during the course of the lawsuit. If you're being sued by a debt collector, chances are good that the lawyer is also a debt collector. You can pretty much count on it, and she can be sued. Before you go suing the lawyer, though, there are some things you should consider, both legal and tactical. There's a concept in the law that makes people responsible for the things people who are acting as their agents do. This is known as respondeat superior. With a few exceptions, an employer is responsible for the actions of an employee. And that means that a client is responsible for the actions of his or her lawyer. In general, this means that a debt collector is responsible for anything that its attorney does. Or to put it a little differently, you don't need to sue the lawyer to attack the debt collector. You can, though. You can sue them both for the things the lawyer did. Should you do it, though? Sue the lawyer? It's primarily a tactical question. Whether or not it makes sense to sue the lawyer is not an easy decision. I know you take the lawsuit personally. It represents a large threat to your personal and financial well-being. So naturally you want to strike back, personally, at the human person you see on the other side. The question is, though, is this the decision most likely to give you the most benefit? Is it most likely to cause them to drop the case and leave you alone, in other words? I don't know. Most of the time, the lawyers suing you regard your case from a purely business perspective and attempt to maximize their profit and minimize the cost of suing you. And much of my approach to debt litigation has been to suggest that people exploit this business perspective by making your case unprofitable for the debt collector. And that's relatively easy to do, although of course it isn't always enough all by itself. On the other hand, if you sue the lawyer, you change their motivation. Then, instead of it being a mere business process strictly about profit or loss, you increase the stakes of the lawsuit dramatically. It does make things unpleasant for the other side, no doubt about that, and this can be an advantage. It also increases their expenses, and that can also be an advantage. See, when you sue the lawyer and the debt collector for actions of the lawyer, you create a conflict of interest between the lawyer and the debt collector. And that should cause the lawyer to stop representing the debt collector and force the debt collector to hire another firm to represent itself. That sounds good, right? But it could also motivate them to work much harder in many cases. You've multiplied your enemies. Remember, the lawyer that you're suing is either going to represent himself or hire another firm to do it. So you'll have two lawyers working against you. And you have seriously annoyed both the original lawyer and the debt collector. You've probably also slowed down the litigation. That's good in my book. And I'd say you've probably made it less or much less likely that they'll settle with you if they can find the materials they need to win. And I'm pretty sure you'll face a lot more motions and procedural tricks. They'll really want to beat you. Here's a legal consideration. If you are suing the lawyer, your claim is not exactly a counterclaim. It's a third-party claim. What you would probably do is counterclaim against the debt collector and bring a third-party suit, that is, within the same lawsuit, against the lawyer. The pleading is just called a third-party suit and names the lawyer as third-party defendant. It states your claim in the same way the counterclaim did. The lawyer has to be served a summons and petition. Remember, you're treating the lawyer as a separate person, and your suit is technically a new suit within the old one. None of this is especially difficult or even important, but it is time-consuming. Given the questionable benefit of suing the lawyer, it seldom seems like a good way to spend the time, in my opinion. You'll have to decide what makes sense to do in your case. Protect what's yours and don't let the debt collectors rip you off. My site and materials can help. Go to yourlegallegup.com. Get my litigation manual and forums, or get the videos and defend yourself. You'll be glad that you did. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forums. If you appreciate this video, please take a second and like it, subscribe, and friend me, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors on Facebook or YouTube, as these things help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.